afternoon, everyone. My name is Florida Kawasinga. Welcome to this webinar of Legal Titans from the East African Law Society. Distinguished invited guests, thank you so much for honoring us with your presence for this webinar. This webinar will happen in the next couple of hours. With us, we have a number of distinguished speakers that are legal titans from Uganda, from Tanzania, from Rwanda, and I think there's somebody from Burundi who might also be joining. Before I introduce the panel, I would like to tell you a little bit about our speakers today before I invite Honorable Powers to actually give opening remarks. One of the speakers from Uganda is a legal titan who's been around for many, many decades in legal practice. His name is Professor Frederick Edward Sempewa. He's a co-founding partner of Katende Sempewa Advocates, a regional leading law firm and member of the Lex Africa Network. Professor Sempewa, my own law firm is part of Lex Africa, so I'm very glad to moderate this webinar at which you're speaking. Katende Sempewa has played a pivotal role in Uganda's U-turn on the death penalty by helping to prove to the Constitutional Court that the death penalty for murder and other offenses was unconstitutional in 2007. His firm had earlier on played a fundamental role in erasing all subsections of the Constitution of the Republic of Uganda that had in 1966 abolished traditional institutions from the country. Professor Sempewa participated in groundbreaking litigation. He appeared in the first case brought before the newly instituted East African Court of Justice and has also been instrumental in the formulation of numerous laws in Uganda. His advice is sought on Uganda's constitutional matters and on regional mandates. Over the years, his firm has advised governments, NGOs, multinationals, and other business entities. One of the noteworthy deals saw the firm give a hand to Warid Telecom Uganda on its $500 million merger with Bharti Airtel in 2013. He has meritoriously earned the title of senior counsel in the Ugandan courts of judicature, and his outstanding scholarly record has made him a leading authority in Uganda on matters relating to revenue law and taxation, constitutional law, contracts, conveyance, and general litigation. He has been instrumental in drafting of various pieces of legislation, regulations, and rules governing regulatory bodies, including but not limited to the Insurance Act, the Tax Appeal Tribunal Act, and its rules, as well as the Ugandan Communications Commission rules. He's a member of the Uganda Law Society and the East African Law Society. That is Professor Sempewa. I will introduce Ambassador Mwanaidi Sinare Major from Tanzania. A career legal practitioner, Mwanaidi Sinare Major was Tanzania's ambassador to the United States of America and High Commissioner to the United Kingdom between 2006 and 2013. She is a holder of an LLM and an LLB, both from the University of Dar es Salaam, and short professional courses in Italy, Tanzania, and the US. Mwanaidi is chair of Rex Advocates, which changed its name in August 2019 from ENS Africa Tanzania Attorneys, the successor firm to Rex Attorneys, of which she was one of the founding partners. She is an accredited arbitrator and negotiator. Major has unrivaled experience in corporate commercial law practice, corporate secretarial practice, and corporate governance. She trains boards of directors of companies in corporate governance. She dominates the natural resources law, mining, oil, and gas practice in Tanzania, and she's respected by the mining companies and her peers. Her other expertise includes banking and finance, competition, property, and energy law. Ambassador Major has worked in the public and private sectors, previously as senior legal officer of Bank of Tanzania and as business development manager, Coopers and Librand, and the predecessor firm of Pricewaterhouse, yeah. She was a director of various public and private companies, resigning when she joined the Foreign Service in 2006. She was one of the founders of Tanzania Women Lawyers Association, established in 1990 to harness the energies of women lawyers in Tanzania to assist women and children who are unable to afford legal services. She was recently appointed by President Samia Suluhu Hassan as chair of the Council of the University of Dar es Salaam. She's a member of the UDSM Senate. Ambassador Majara is also a member of the board of directors of TANESCO, the National Electric Company. She is past chair of the board, Bank of Africa, Tanzania Mozambique Center for Foreign Relations, Vodacom Tanzania Limited, now a public company, and the Ngorongoro Conservation Area Authority. In respect of social responsibility, she is chair of the Hassan Majara Trust, a charity established in July 2011 in memory of her late son to help improve the learning environment in schools in Tanzania. Its flagship program, A Desk for Every Child, aims to ensure that every child in Tanzania has a desk and has removed over 30,000 children from the floor onto desks over the last 4 years. Mr. Richard Mugisha from Rwanda is described by his peers and the legal profession as an outstanding individual lawyer. Mr. Mugisha practices in Kigali and is a high-profile lawyer who acts for a number of international and domestic entities, including investment companies and energy providers. He is well-versed in advising on corporate and financing transactions, including those pertaining to energy and infrastructure projects. He holds a Bachelor of Arts degree, a Bachelor of Laws degree from the University of Lesotho in 1994, and Master of Laws LLM from New York University. He's a senior partner at Trust Law Chambers, a leading corporate and commercial law firm in Rwanda that he founded in 2004. He was formerly the manager, procurement policy, legal affairs at the Rwanda National Tender Board for 5 years. In the academic domain, he has taught and conducted tutorials at the University of Rwanda and Kigali Institute of Management, Science and Technology. He has led numerous assignments in energy, infrastructure, mining, as well as banking and finance, and has been at the forefront of almost all the privatization deals in Rwanda. He is cited by Chambers and Partners as a band one attorney who is go-to lawyer and a great negotiator, and a leading lawyer by IFLR 1000 legal directories. He served as the president of the East Africa Law Society from November 2016 to November 2018. He's also a fellow of the Africa Leadership Initiative and the Aspen Global Leadership Network. He's a member of the Rwanda Bar Association, the East African Law Society, and the International Bar Association. David is the speaker from Burundi on the call, so I can introduce him or not?
Madam Moderator, not yet, but he says he's joining.
Okay, I'll introduce him when he does. Let's kick this off by inviting the president-elect of the East African Law Society, who is on the call, Honorable Justice Dr. Fawz. Please, can you give your opening remarks? You are muted, Honorable. Justice Fawz, you're muted.
Oh, thank you. Thank you, Florida. Dear participants, facilitators, fellow members of the East Africa Law Society, good afternoon to you all. You would have noticed that it's only last night that I appeared in the flyers, the banners, to replace our president, Mr. Bernard Oundo, as the person who will be giving welcoming remarks this afternoon. So I'm sort of a last-minute gate crasher here. But it's an opportunity that I am very thankful for. I thank the East Africa Law Society, especially the president, for giving me the honor and privilege of addressing this very important webinar. You would agree with me when I say that it is a very important webinar, because the theme brings up an issue that is bread and butter for us lawyers, central to the continued survival of the legal profession, not only as a profession, but an essential one at that. I would therefore like to stress the need for efficiency and new thinking in law, the need to look at alternatives in traditional legal services, and the ability to apply a business mindset to every task that a lawyer is called upon to perform. Hence, in discussing the future of the legal profession, the facilitators will, I hope, give us some flashback of their own personal experiences, and then lead us to look at where the profession is going, where it will end up in the near future, mid-term and long-term, and how to prepare ourselves for this change. By the future, I believe we would not be talking about the next generation of lawyers. Change today is a very fast-moving thing. By its nature and speed, it is mind-blowing. Only 3 years ago, we would not be having this kind of meeting where people from all over East Africa are meeting at one place, in somewhere in the sky, having a discussion and exchanging ideas in a setup of this nature. So it is something that has developed much more recently. And with that kind of thing, one would have to think of situations where, for instance, people are talking about artificial intelligence as a way of solving legal issues. How are we prepared for that, or preparing ourselves for that? A world where there will be a time when the lawyer will be replaced by a computer app, and matters of law are resolved by way of a computer. So what I'm saying is this, that speed the speed of change is so fast that we shouldn't be worrying about the current, about the next generation of lawyers. We would be, I think, better placed to worry about the current generation of lawyers. In the next 5 years, maybe most 10 years, because we will get there very, very soon. That future is already with us. So these issues are so crucial in my view, and quite some time sensitive. And that is what makes this webinar so important. And the underlying issue for us is whether we will be the creators of change. That is that we as lawyers would be able to direct our evolution from within the profession, or will be forced to change by elements from outside the profession. Will we be proactive or reactive? I think there is very little choice there. We need to be proactive. We should change from within and be able to influence change around us. Having this in mind, I hope that you will have very fruitful and enjoyable discussions this afternoon, and I wish you all the best. Thank you very much.
Thank you, Justice Tribe, for those very interesting words, especially sounding an alarm that we, tomorrow is already with us. We have to make friends with technology, to make sure we go with the times, to make sure that we in practice are not irrelevant and not going with the times. Thank you very much for those remarks. And thank you for gracing us with your presence for this webinar. Thank you.
Thanks.
Now, turning to our panelists, Richard, today is Richard Mugisha's birthday, we are very grateful that he managed to come in and be with us. I will start the session with Professor Sempewa, a question to you. And to the participants, please feel free to use the chat to send comments, to send questions. Professor Sempewa, as senior counsel, you have been in practice for more than 30 years. Could you share with us some of the highlights of your journey as a lawyer? What have been the highs and lows? Professor Sempewa, I think you are muted.
Thank you, Madam Moderator, and I thank the organizers for this opportunity for us to exchange views Yes, I have been in practice for many years, much more than 30, in fact. My experience, of course, is long. I might have to give you a background about where we started. As you recall, the colonial government was not interested in training lawyers because they were troubleshooters. They would fight for people's rights, demand for independence, and so on. So most of the institutions they started in the colonies concentrated on teaching other humanities or the professional sciences like medicine. And the university in Makerere concentrated on medicine and other professions of the scientific nature. It took a bit of struggle for the law to be taught locally, that is in the region. And that's how the University of Dar es Salaam, University College Dar es Salaam, was set up as part of the University of East Africa. And we are privileged to be some of the early students in this institution. But the training there was all British oriented, and they had a bent for barrister, for litigation, and we are trained mostly for litigation and not any other law jobs. And during that time, no one would be happy to be called a lawyer unless he appeared in court. So we had even a local name called calling lawyers pleader, out of pleader. So we started practice concentrating on litigation. The market was very small. And of course, also the professional community was small. There was little competition, and hence we didn't enlarge in modern trends of business development. We always thought we would get clients. Another peculiarity of our practice was the absence, the virtual absence of specialization. Most lawyers would be jack of all trades in that small available space of litigation and a few transactional areas, really drafting of contracts between individuals. Then, as we started early 70s, there were really no international transactions to speak of. And Uganda was unlucky that during that time we had a regime that fell out with the international community, and that made matters worse. The other peculiarity was the small firm, which was the order of the day. When we started, we were just two. We were joined by other lawyers. We became 4, eventually 5. And we were celebrated as a big firm in competition with the other 2 big firms, which really were established by the British. There was Hunter and Gray, and another one which I can't recall very well. So that is the scenario we are in. Now, the environment for practice, if we described it for you, you might think that it was almost impossible to practice, but it was, because that was the order of the day. One, we didn't have modern means of communication like we have today. There were telephones, but only landlines. And if you were lucky, you'd have a line at your desk, but that was for really privileged people. In our firm, we had only one receiver, and the operator will have to call you out of your office to go and receive calls. Much worse if you had clients who wanted to speak to you on phone, they probably would have to warn you through letters that on such and such a day, please be near telephone because I'm going to call you and give you a message. There was there were no word processors. We had typewriters where you could type and retype because it was very arduous to correct mistakes. Eventually, we got improvements introduced into telex, then fax, and then the modern means of communication as we have them today. But those were later developments. For a long time, we had to do with what was available, and that included research. Having no internet, you had to go to a library or stock hard copies. There was no way out. Practitioners born of recent years cannot imagine that this was the life we were leading. I remember my first case was before the East African Court of Appeal. It's not the East African Court of Justice I'm talking about. This was an appellate court for Uganda, Kenya, and Tanzania in all matters. And it used to have sessions in the capitals, Dar es Salaam, Nairobi, Kampala. Now, to appear before the East African Court of Appeal was a big issue, especially for a young lawyer. And I had to, so I spent almost 2 weeks of sleepless nights preparing for that case. And these 3 judges, all foreigners, British, came in, and I had to rise up, started sweating. And when I started, I was like, machine that had been switched off, having prepared thoroughly. I went ahead, and the judges said, no, slow down, young man. We want to follow. So they guided me to go issue by issue. After the 3rd issue, I said, but you can't stop there. We think we have got your points. Leave the rest to us. I was dumbfounded. I thought a miracle had happened. I thought I would spend there hours of sweat, but that showed you that, or it should show our young lawyers that, you have to respect our courts, you have to prepare. These days I see lawyers turning up and simply casually throwing around words without preparation. But maybe let me stop there. We'll continue the conversation since it is really a conversation.
Thank you, Professor Sempewa. I'm always amazed at how much you're committed to this profession. When you're invited to webinars, you come and speak to the young people. You're always present at conferences at the ELS. You're very committed. You're very committed to ULS as well. I saw you at the conference last week in Kampala. And for that, we are grateful in the legal profession because we learn from the titans. Ambassador Sinara, same question. We want to hear from you about your experience, the highs and lows of your profession, your professional practice in Tanzania.
Thank you very much, Professor. Appreciate you are looking back. And thank you, East Africa Law Society, for organizing this get-together. I will speak about the beginning and the progress and 2 hilarious issues that happened to me, and then, of course, lessons for the future. I started practice after a short, not short, about 7 years with an accounting firm that hired me to lead their business development practice, which was really a legal practice in disguise. And that's from there that I cut really my professional practice. And that's the reason that when I started practice, I went straight into commercial corporate practice because that is what I learned during my work with Coopers and Lybrand, which became PwC, PricewaterhouseCoopers. Now, and I was lucky. I started exactly the time Tanzania was closing the chapter on a command economy, walking into the liberal market economic practice, which was a good environment for a corporate practice. We didn't have any corporate practice at that time. The only lawyer doing corporate was my brother Nimrod Mkono and late Bob Makani, who was my boss at the Bank of Tanzania as deputy governor. But like my small practice, they were also only solo. And we remained solo for a while. Tanzania, during the command, public operations received legal services from a public corporation called Tanzania Legal Corporation. So they would do all the public work, and lawyers would do only criminal legal practice because that was the business available at that time. Now with the opening up, clients were coming, private sector were coming to us. The few who were with PricewaterhouseCoopers were those who were coming for audit services and accounting services, and that is how they would seek legal services. And because there was no private legal practice doing corporate at that time, the accountants did it. So that's how we started, and it was we were so lucky to become a very successful practice. Now, solo for about 3 years, and then I had a client, and this client was Total, the then UK-based general counsel for Total came to Tanzania because Total was selling some of its assets. And having gone to Nimrod Mkono and to Bob Makani and to me, and then came back to me, said he was going to hire me, but exceptionally, because Total does not hire solo. He said, what if you die or you become incapable? Well, the transaction is not yet done. And he said that without hesitation, and then offered unsolicited advice. You should take on a partner. And I took that unsolicited advice because he became a friend. He was going into retirement and even brought books to me. He was reaching his retirement age. So he sent all his office books to me. At that time, that's how Mahaja Rwechungura Law Office was born, from Mahaja Law Office. Then we continued to practice local, and as the economy was opening up, we became quite successful. Now, in those days, there was no mentor. There was no, of course, I heard of Professor Sempembwa, but it's not anyone you would even dare call if there was an opportunity to call. There was no one to help you. So everything that we learned by doing on the job. But for me, the game changer came when I had the first opportunity to work with an external law firm, which was Kaplan Stratton. And there were two assignments, one after the other. There was one, a privatization of a public hotel, where Kaplan was instructed, and they worked with me and literally holding my hand throughout the process. And then next came disposal of assets of the East African breweries, some of the assets based in Tanzania. And again, Kaplan Stratton was literally training me. And I've remained very grateful to this firm because this is the firm that actually changed my capacity, that built my capacity. And after Kaplan, because the business was opening up, more law firms came out. Clifford Chance from UK, we were doing a purchase of assets of a Match Corporation in a receivership. And then Becker McKenzie, we did some business. And then came a Canadian law firm in the mineral sector, which really helped me, along with another UK firm with which we did the review of the legal and regulatory regime for the mineral sector, helped me develop my practice. They became unknown mentors for me. It's not like today you would have the local bar and the East African Law Society doing this kind of webinars or talks or discussions during the annual general meetings or CLEs that the younger lawyers are enjoying. Some of them not even bothering to attend, which is very unfortunate, because it's such a pool of knowledge that if you meet someone like Professor Sempebwa, even over a cup of tea, or even when he's doing some training, it should be an opportunity that the younger should not look. So that's how it was, and that's how we learned. There was no Google, of course, there was no social media, nothing. And the working tools were really, really a challenge. And Professor Sempebwa mentioned the issue of telephone. Imagine when you're working without internet, or Google, or word processor, or the social media that people can reach clients remotely, or where you only have to correct a complex draft agreement by typing on it, doing something on it, and then typing again and going. So, but this is how we worked, and somehow we managed, but it was a very slow process that we had compared to what is happening now. So the possibilities of today are so great that you cannot imagine of how we would actually operate without them, even for those who lived in those days and today. So when you talk of lack of mentor, I will give one very interesting thing that happened to me. One day, a client, I can't remember whether I sent a fax or called me and inquiring on the procedure in Tanzania for challenging a passing off. And you know, I was passing off. What is passing off? So I call my colleagues, those I can talk to quickly. No one seems to understand. I didn't have a law dictionary, something that today you would just Google. And I was like, what do I do? So my idea was to consult one of the leading lawyers here at that time, Mr. Uzanda, Professor, you must know Mr. Uzanda. And I called him. Someone gave me his number, I called him. And he said, who are you? I introduced myself. He said, are you a lawyer? I said, yes. He says, sorry, I talk only to partners. I said, I'm the partner. And he said, okay, what is it? I said, I have a problem. May I come to your office? He said, okay, come. So I went to as on the phone, he says, I said on the phone, what is passing off? He said, passing off. I said, yes. I thought you said you were the partner. I said, yes, I'm the partner. You don't know that? I said, I don't know what it is. Can you please help me? So he says, come to my office. So I go to his office. He tells me what is passing off, the easiest thing you can ever do, and then gives me books to read, and then helps me to understand the matter and the procedure that you would have going to court to challenge a person off. And I went back and responded to my client as if I was a very good lawyer. That's one situation. But today, you just maybe have a Black's Law Dictionary, or maybe you would just Google that out instantly from your chambers and you would attend to the matter. Even today, you just have to say, what does that mean? And you have the different and various meanings of passing off. The other thing which is also a bit hilarious was in those days, and Professor September mentioned a telex. Many of the practitioners, and I'm sure Florida, you don't know maybe what is a telex machine. Telex machines were our emails those days. So I was one of those few lawyers who could lease a telex machine from the telecommunication company. So I leased mine, and I was using it for some time. When you type it, some little tiny paper come off, like rice. And then it sends message. Clutch, 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 and it sends message to the other side. Now, I used it for a while, not too long. Very proud of it. And one time I was approached by an Australian client inquiring on the legal and regulatory regime for the mineral sector. And I explained on the phone very well, and he was quite impressed and said, "Can you send me a written legal opinion, please?" And I said, "Oh, sure. Would you give me the telex number so that I send you?" He laughed and said, "Telex machines don't exist in Australia anymore." So that technology had died, and I here thought it was still available. So he said, "Can you email me?" I said, "Come again? Can you email me?" First time I heard of the word email, I said, "Yes, please, I will." Then what do? I start asking, what is an email? So I went to a friend, Magdalena Rubangira, a fellow lawyer, who had just come back from the US. I said, "Do you know what is an email?" And she says, "Of course I do. I even have an email address, Hotmail. Can I have one?" I said, "Of course you can." So she shows me how to do an email. I get the email of this client, and I sent an email for the first time in my office. Why am I
What year
saying
was this, Ambassador?
Pardon me?
What year was this?
94. So I'm saying this because people like Florida and others, you can't understand how far we have come in terms of legal practice in East Africa. And we have really come a long way. And lessons from these two examples I'm giving you is, I'm giving you these examples only so that you can appreciate, the younger generation can appreciate how far we've come, what you need to do to survive, and to survive for the younger lawyers, and even for us during our time still, is how we're going to handle the changes, the profound changes that are coming with the digital revolution, with the virtual revolution, with the industrial revolution, fourth industrial revolution, bringing artificial intelligence, which is actually squeezing into the legal practice faster than we even ever imagined. It took so long for the internet to become predominant, but it is happening so fast with the artificial intelligence that we have firms like Allen and Overy and others, the global, huge global, mega global law firms using artificial intelligence to actually analyze complex contracts and helping corporates manage those contracts, assess contractual risks using artificial intelligence, not lawyers, not human lawyers. And these are competing with us. Consider the fact that when I started practice in 92, 91, I was not even allowed to announce my presence to clients. How did I do it? I had to publish notice for recruitment of a secretary and give him my address so that clients would know I have my practice. And I was reprimanded by the Bar Association. Today, you have the Facebook, you have Instagram, you have LinkedIn, you have your own website, and people can reach out to you. They know. Today, when we meet as East Africans, we talk about cross-border practice and, oh, you're not coming to practice in my region, you're not going to practice where? We are actually hiding our heads in the sand. The global law firms are practicing in our region today. They get instructions via email, they give legal opinion via email, and when they want to validate that legal opinion, they will come to a local law firm. But they already have that legal opinion. Sisi bado we are saying, oh, you know, Kenya, you cannot come set up practice here, or Tanzania, you cannot come set up practice Uganda or Kenya or Rwanda. This is the practice now is out there in the open. The competition is out there in the open. It's not the physical knowledge, it's the artificial knowledge, the viral. And it is happening in real time. It's not like it's going to take long before artificial intelligence is also applied here locally, or they apply to the contracts that our clients locally are actually negotiating. So we really have to try to hasten our process. And this is scary, because when you look at some of the law firms, we still don't even have emails. They still are using Gmail. And clients look at you and they see a Gmail and they think, this one cannot help me. I need one who is more settled. They will know your capacity is limited. We now have law firms, virtual law firms. They have no office, no physical presence, but they have clients, and they are hiring young, bright lawyers who like flexi time to want to do. They want to work and play at the same time, and these virtual law firms are allowing them to do that. They pay them well. They charge less because they don't have the baggage of costs of rental offices, and their work has now been more validated by the coming of the pandemic, that now confirmed that we can actually work remotely, not necessarily straight. So you just have an address where maybe you meet clients, and that's it. And this is a challenge that is coming our way. We really have to try now to see and reorganize ourselves and to see how are we going to deal with these profound changes that are actually creeping into the legal practice, not globally alone, but also right back into our own backgrounds, into our own offices. So what do we do? As the East African Law Society, as members, we need to actually start planning. We need to start knowing the future is here, that virtual practice is here. Artificial intelligence doing our work is here, and it's affecting us simultaneously now, virtually, in a way that we really need to address it. And you can see it. So many disruptive elements that make it something that you can no longer ignore. Even looking at the phone itself. The phone, the mobile phone itself, it's everything. It's your library, it's your Wikipedia, it's your legal dictionary, it's your calendar, it is your communication, it's your news, it's your, you will read your magazine, you get your court cases through the mobile phone. It's just so profound. We haven't stopped to think about it, and I think it's time to stop to think about this profound change that is happening and how it's going to impact our practices in East Africa. I think I've said too much. Thank you.
Thank you, Ambassador, for those insightful comments and discussion that you have talked about. It was very interesting to hear about your experience with the telex and the email, and I was very curious when those things happened, because it's very difficult for people of this generation to actually understand what is to happen in the day. We have about more than 200 participants on the call from all over East Africa, and they're sending in questions and comments. But I wanted to ask you specifically, Ambassador, because you're the only female that is here with us as one of the titans. Did you face any challenges because of your gender? I'm sure the young legal practitioners that are on the call that are female are very interested to know particularly your experience as a female lawyer in the past.
Oh, I do get this question quite often, actually, but I don't get it from lawyers. No, I didn't. I mean, who would intimidate a lawyer? It's and also from the legal fraternity. Somehow I think the male lawyers look at us just like colleagues. My partners, at one time, they were all male, and I was sometimes I wanted to play the card of, you know, the lady here, and they would say, we don't see any lady here, we just see a partner. So, so I haven't had really issues about that, or because I'm a woman or anything like that.
Thank you for that. Let me read some of the comments in the Q&A. This one is from somebody who did not give their names, but it's for Professor Sempewa. It says, thank you for the webinar. Please request Professor Sempewa to request the publishers of his book, East African Community Law, to make copies available in the bookshops in Kenya. Professor Sempewa. Someone called Hassan Yusuf Twenge says, I remember using telex machine from my boss, MP Nimrod E. Mukono, from Mukono and Company Advocates. Those days were awful. Keep those comments coming. Richard, could you please turn on your video, Mr. Mugisha? Professor, in the meantime, you want to make a comment about your book and the request?
No,
we also are looking for that book.
I have received the message. I'll work on it.
Okay. And Ambassador says she wants a copy too.
I think one of these days, I don't know whether we can discover the machine, the telex, anywhere. It will be interesting for people to see it.
For museum.
Professor, I think Ambassador Sinare would like a copy of your book. Maybe you should sign one and send it to her.
I'll see how to get it. Yeah.
Okay.
Richard,
you, could we have you on video, please?
I think the host has stopped the video. So, David, can you
turn on Richard's video, please? But in the meantime, we can start with the same question. Oh, there you are. Richard, as I said earlier before you came on video, that we are grateful to have you on your birthday. Happy birthday, and thank you for leaving your golf game to come and grace us with your presence.
Yeah, thank you very much. I think you helped me to sort of apologize for my dressing this afternoon. I would have preferred to be professional and wear a suit, but I thought about choosing between this and the golf game, and I felt like doing both was the most appropriate. And so, yeah, thank you for inviting me to be part of this conversation. Obviously, I haven't been practicing for so many years, like my seniors here, Professor and Ambassador. And I probably also think that it's not very easy to find lawyers in Rwanda with this kind of experience, this length of experience, given our historical past. Now, I finished my legal education in 1995. At the time when I came to Rwanda, I mean, for lack of a better word, I would say things just looked crazy. Everything was a priority. And for some strange reason, we were also very few lawyers because even the ones that had trained outside the country trickled in like slowly. Yeah. Previous governments before the genocide had made it, it was a deliberate policy to train very few lawyers. I think from what I understand, they used to train very few lawyers, and even then, like every 5 years. Now, with the genocide, those very same lawyers were either in exile or they had died. So there were very few of us having to do lots of things. And the one thing that I picked up as a very important attitude for every young lawyer to have is that you have got to allow yourself to remain teachable. Because here I was, having trained in a different legal tradition and having to do lots of different things in a country that, although I call mine, I was only getting into for the first time at the age of 26. And official language was French, mainly. Kinyarwanda is also very widely used to this day, but again, because of this historical context of mine, here I was, someone whose first language is Luganda, having to operate in Kinyarwanda and French. Both languages I was not very conversant with, but I had to find my way. And before long, both my French and Kinyarwanda had improved very much. I started off with a team that was investigating genocide perpetrators, but everything at that time was a priority. Before long, I had been moved to a team that was working on a legal framework for the Rwanda National Police, which was aimed at consolidating the various law enforcement agencies to bring them under one unified command. So you can imagine, no police experience, no Rwandan experience, but I have been asked to lead such a team. And I remember telling the head of the police at the time, who had been assigned the task of consolidating every other agency, like, but I have no knowledge of security. And then he simply said, there are so many people who have experience and knowledge in security, but they lack one thing: they are not Rwandan. So we will arrange to get you people that can work with you, but you, as a Rwandan, you have to take the lead. And so we had some police officers come from Zimbabwe, and I worked with them to establish to draft the legal framework for the Rwanda National Police. Interestingly, much later, when I was applying to go for my master's in NYU, that stood out as the most important experience that was considered for them to admit me and even give me a full scholarship. From the police, then there was an urgent need to streamline government procurement. And there I was. I'd never done procurement at university. I didn't even know there was a lot of law there. And so it became another learning curve. Just thrown into the deep end of the water, of the pool rather, and I had to swim. Learned a lot during that period. I was learning and also doing and making lots of mistakes, but eventually it did work, and I think we were able to come up with a very strong institution that serves the country very well up to today. From there, I felt I needed to take a break and go for further studies, and that's when I went to New York University after 7 years of service. And being in New York City, as you can imagine, lots of exposure to many things. And it was at that time that I got interested in starting private legal practice, because it was very clear to me that serving my country, which was very central to my heart, was not mutually exclusive with making money. And the Americans demonstrate that very well, And so when I returned, I mean, at the time there was also massive training of lawyers, so we had quite a critical mass, and I didn't feel that I was very much needed. I could serve in a different way. Thankfully, my bosses in government at the time welcomed the idea and allowed me to set up the firm in 2004. That in itself was very challenging because, again, even though I'd made a lot of progress language-wise, I could not, manage to communicate very well in court. And so I figured that I could thrive best as a commercial lawyer, because commercial transactions are quite similar all over the world, and that space was also it had, I mean, the business people themselves were mainly using English, so I figured that was probably where I would add most value, and plus I generally like business deals, so I was also, I was in my element there. And however, that was still not easy. I was dealing with very many new things, and the attitude of remaining open and teachable and educating oneself came in very handy. I remember working on a privatizing transaction for a bank here, and I had no clue about many of the things we had to address, and I would spend so many nights just reading up. But I was lucky to be working with an American lawyer who was doing his 150th bank acquisition transaction. So like everything was on his fingertips. And so I asked him so many questions. Thankfully, he was very generous with his knowledge and he guided me a lot. But however, I also found that your biggest asset as a lawyer is to know your landscape, your local landscape very, very well. Like, know your local laws, know how the institution functions, know the people. Because in as much as he knew a lot of the legal aspects of acquiring a bank, he did not know my country, he did not know the people, he did not know how things work. And so we ended up helping each other in terms of bringing what one's best attributes were, and working together, we were able to successfully conclude that transaction, and that paved the way for many other privatization transactions in which I was involved. And it's interesting, some of these things look like they're rocket science. You only do one and then the rest becomes very easy. I also remember having to work on a capital markets transaction, the very first one in this market. And I didn't know how to proceed. And again, here, I would like to encourage the young people here to invest in relationships beyond your jurisdiction. Because I got a lot of assistance from a lawyer who is actually Professor Sempe was partner, Sim Katende. I reached out to him and he guided me on how to conduct the necessary legal due diligence, on the basis of which a legal opinion required for the transaction would be based. And, you know, having done that with SIM the first time, we have done lots of other transactions since very well. And, you know, everyone, the clients are happy. And so for me, I would say two things: remain teachable, have an open mind, invest in learning the technical aspects of every business that you advise, invest in relationships, because they are always going to come in handy, either in terms of helping you to master the legal aspects of what you're dealing with, or even to develop the business itself. I think one of the aspects, one of the questions that I was asked was, what has been the most hilarious event? I would say it was one in which our moderator here was my counsel, as I challenged some provisions of the penal code that I thought were unconstitutional. And so I instructed our moderator, but I also worked with her. And the Supreme Court agreed with us in some of the provisions of the penal code and ordered that they be stricken off. We did lose on some others, but that was really a very defining moment. Interestingly, it is probably the matter on which I gave a lot of time and did not earn a thing, but it turned out to be the most satisfying. So I guess I'll stop there. I don't know if I've touched all the questions Florida you asked.
Thank you, Richard. We'll continue this conversation, but in the meantime, I wanted to read some of the sentiments from the participants. Thank you. This is from Rachel Akelo, who I assume is in Uganda. Thank you for organizing this webinar. I am a young professional who just completed her postgraduate studies. Things can really mean to be confusing. You are trying to find yourself in the career, trying to make money, and so many other things. This session is really insightful. Somebody called Hassan Mtwenge says, I think we misconcept the concept of artificial intelligence. Most of the international law firms and accounting firms, the big four, are invested in AI. The good thing is that the human part will still be there. AI is there to make things look easier to us, but not to replace us. For example, what does computer evaluation, does computer evaluation does to us? Does it replace us? No, still human part is there. Lydia Namuli says, thank you so much, Ambassador. And she also says, I hear you, Ambassador, you are right. Thank you, East Africa Law Society, for organizing this webinar. We'll continue with the comments and questions, but I want to now recognize the presence of Antoine Zavandora, who is an advocate from Burundi. I didn't introduce him before because he wasn't on the webinar, so I'll just read out his bio quickly before he also has to answer some questions. Mr. Antoine Zavandora is an advocate of Burundi Bar Association since May 1998. He has a degree in law from the University of Burundi, and from 2007 to 2008, he was nominated as the UNESCO chairperson under the DESS in Human Rights and Peaceful Resolution of Conflict Study at the University of Burundi. He served as an ELS Council member for 15 years from 2003 up to 2017, and is a senior partner of Zavandora and Nzeyimana Law Office in Burundi. Before joining the bar, Mr. Zavandora worked as a field coordinator for NGOs, CRS, and Caritas's project in Burundi between 1996 and 1998. He served as a judge of Tribunal de Grande Instance in Burundi, and also nominated as the president of the Tribunal de Grande Instance in the province of Ruyigi in Burundi. Mr. Nzabandora has also worked as a coordinator of a global rights project whose mandate is to give grants for legal aid for two local NGOs called CADDRO and ADDF in order to implement a project named Action Judiciaire Stratégique in Bujumbura, Burundi. Mr. Nzabandora has also advocated for the acquisition of grants from many international NGOs to offer support to legal aid projects in the specific field of women abuses in Burundi. In addition, he has taken part in the management of the projects by providing regular legal policy and frameworks. He has also published a number of publications. They are in French: Expression du consentement d'un État à être lié par un être. Okay, I give up. I tried the French. Mr. Nzabandora, welcome. The questions that the other legal titans were answering is, you have been practicing law in the region for a very long time. Could you share with us part of your journey? What have been your highs and lows? You are muted. Could you unmute?
Thank you. Do you hear me?
Yes, we do. We can hear you now.
Thank you very much. As you said, my name is Antoine Nzabandora, and I'm a lawyer, practitioner from Burundi. And my experience as an advocate, an old advocate, I'm not a titan, as said by organizers. I'm not a titan. Maybe I will be one in coming days, but I'm not sure. First of all, I would like to thank, I'm sorry, Mr. Sempebwa, Professor Sempebwa, whom I know I've met in some occasion in ELS AGM. And I would like to thank, of course, to the ambassadors, Mrs. Sinare, whom it's the first time I see her, but I was very interested to share his experience, long experience, and full of many things. Of course, my colleague Mugisha also told us many things about his legal practice, and it was very interesting to me to hear that in a short time he has made many steps, many progress. And here, of course, in Burundi, our bar is very old. It seems to be very old because it was created in 1950 by colonial rule, and until 1967. It was composed by colonial advocates, Belgian especially. And from 2009 and 67, it was the first time a Burundian was admitted as advocate. Myself, I'm not very old I'm not, my experience is not very far as said before by the previous panelist, because I was admitted in 1098. It's now 21 years, 24 years as an advocate in Burundi Bar Association. So what can I mention? Very important. I was the first advocate to participate in ELS AGM, which was held in Mombasa. It was our first participation, and I was there to receive our admission as a full member of ELS. It's something which I'm very proud of, because at that time our bar was not a member of ELS as it is now. The other thing to mention is that, of course, because before I was admitted as advocate, I was a judge, as said in my biography. I was a judge, and for 7-8 years before I joined the bar. At that time, before that moment, our bar was very poor in number of members, because when I came, I remember the number of advocates was not over than 20. Now we are, of course, we have made many progress, but we are not far, because we still have 800 advocates. Among them, we have 300 females. It's something which is very interesting, because here in my country, women are emerging very fast. The other thing to mention is how our profession is organized, and how it can be conducted. Of course, as the other country which with the human rights not very developed, many advocates are regularly involved in human rights matters, political cases, and since the crisis which was broke in Burundi in many occasions, 1092 and 1993. And recently there was, of course, 2015. At that occasion, there is many cases many advocates were involved in human rights cases. Myself, I was also involved in such matters, and of course, as a judge, it was not very complicated for me to be involved in the judiciary cases, like criminal cases, and of course labor cases, and commercial cases. Yes, but not many. According to my situation, not many in commercial cases, but I was mainly involved in criminal cases and labor cases. And of course, how to what to say to younger generation, to young lawyer, is that of course as a beginner in our profession, it's not easy to survive. It's very complicated. But what to do is to have courage and to resist and to hope, and of course to work very hard, because it's a kind of competition. If you give up, then you disappear. But when you take a time to resist and to work very hard, to of course to be not to there is something new which is been spreading very fast. It's something which everybody know, is the corruption. If an advocate is involved in corruption, then it's the beginning of your the disparition, because corruption finally everybody know or learn that we are corrupted. So what to say to young lawyer is to be aware of corruption and to be far from that kind of criminal, that kind of matters. What the other thing to say is that, of course, as Burundi is a teeny country, with many people, and lawyers are not many, of course, as you can see, but the risk is that if there is no sustainability to help young lawyers to come up of minimum of their needs, I think it will be very hard for our profession, our bar, to develop itself. And of course, I would like to mention that now things are becoming much more better than previously. Let me stop that and stop there, and hope that my English, which is continue to improve, will be much more better in the coming days by practicing, by exercises, of course, and by doing such things like webinar. If you involved in such a discussion, then I'm sure we'll make progress. Thank you very much.
Thank you very much, Mr. Wandera, for those wonderful insights into what happened. And your English is perfectly well. I understood you perfectly well. And as the DRC has joined the East African community, we are increasingly, as the East African Law Society, going to have to diversify and hopefully do webinars in French for our French-speaking membership. And that, I think, will make you more comfortable when you speak at such events where you speak a language that is much more comfortable for you. Thank you for sounding an alarm on corruption. I am going to read out some questions and direct them to particular presenters. Professor Sempewa, I'll give you the first question, which is from somebody who is an anonymous attendee. They didn't include their name. He or she says it would be good to hear from our seniors on their views about writing within the legal profession. Are we doing enough writing to condense our experiences and learnings in practice to guide the growth and development of our laws in East Africa? If not, how can we grow our jurisprudence through writing? How can we support our seniors to write about their experiences and learnings to better inform upcoming practitioners? It's a lot in one question, but Professor, I'm sure you'll do it justice.
Thank you. Yes, I think this is a very important, I think it's a question, but also a proposal, because really, I think we are lacking in exposing our experiences. We haven't been that active, even to tell the story as we are telling now will be useful to the legal fraternity, even without going through academic discourse in various areas. I know that in all the teaching institutions, teachers are making efforts to develop the jurisprudence, and books have been written, articles written. But beyond that, I agree with the person who has posed this view that for experienced lawyers to talk about their experiences in writing would be very, very useful. It would assist in improving our society. You know, the council from Burundi has been talking about integrity, which is a very important thing in our society. It's alarming that the trend is going to the worst, at least the observation in Uganda. When I was started practicing for the first 15 years, I didn't even know whether we had a disciplinary committee somewhere, because nothing was happening. All lawyers were expected to behave with integrity, and we did. But since the late 80s and so on, things have been getting worse. So we need to talk to our lawyers through writing about issues of integrity, issues of how to devote our efforts to serve our clients, counsel-client relationships, which is a very important thing, because unlike in our earlier practices where we had been indoctrinated that law is a honorable service, it's not a business, it's now accepted that law is a business legal practice, and you have to know how to deal with the clients. So I would call on all senior lawyers, and I think if you've been practicing for more than 20 years, you are a senior lawyer, to devote their time to putting on paper their experiences for purposes of mentoring the young profession. I know that the Law Society in Uganda has put up a bit of seminars, and have tried our best to go into this, but writing would be an added advantage. I'll stop there about the question.
Thank you, Professor. And I think from what you've said, combining it with the sentiment from the attendee who wrote that particular comment, I would also encourage young lawyers who are interested to put this in writing, to actually approach the senior counsel like yourselves and interview them, and just put the writing out there. I think for posterity. In Africa, we usually have oral history and all of that. It's not always that people are very keen on writing, but for young lawyers who want to write this history, they should feel free to approach some of the senior counsel and actually put their story down in writing. Ambassador, the next question is to you. What is the opinion, and also this is from another anonymous attendee, I'm not quite sure if it's the same person. What is the opinion of the legal titans regarding advocacy? Has the quality deteriorated over the years? Has virtual courts made the situation worse? You are muted.
I can't claim to be the best person to answer this question. The reason is for many years I am not a litigant. I do litigation only in areas that I have to give support to a litigation partner or partner who is in the disputes resolutions practice. But advocacy has, in my view, deteriorated. Not only, and especially in Tanzania. I cannot speak very well for others in the region. In the courts, especially, started when we started having hearings, not in open court, hearings in chambers. And I remember when I was a very young lawyer, the best benefit that you would have from open court hearing was just enormous, in the sense that you hear the arguments and you see the best practitioners putting forward their arguments, and you're learning as you wait for your matter to come up. Now that is no longer in many respects, so that's one. And number two, advocacy also comes in public interest litigation, where there is a lot of interest and for public advocacy and for other things, and also for us women lawyers through the Women Lawyers Association, matters that concern the rights of women and the rights of a child. There's been a lot of advocacy there. But there is a limitation here where we have now legal restrictions into bringing to court public interest cases, which has squeezed the space for public interest litigation. So yes, there is some kind of a deterioration in legal advocacy. And also the want of writing, as the questioner suggested, writing about jurisprudence in East Africa. During our days, I remember, especially because the law faculty for East Africa was then Dar es Salaam, a lot of academic writing and advocacy writing was specifically covering the 3 East African countries, and you would have examples coming from all the East African countries. So there is a deterioration there. That's my own view. Other lawyers obviously will have a different opinion.
Thank you, Ambassador. Richard, are you there?
He's gone for his birthday?
He might have gone back to the golf course.
No, I'm here.
Happy birthday.
So somebody called Ferdinand Keicha
Yes.
has the following question. What's the
Yes.
general and specific piece of advice that our forerunners in legal practice have to us young lawyers when it comes to prioritizing between legal knowledge development vis-a-vis making money, as things seem to be real tough? We need to improve our knowledge in legal arena, but at the same time, make money. Making money has been a big challenge, which in turn affects the ability to improve our legal knowledge. Your advice, please, on this. Thanks in advance.
Well, I think I would say this. For especially young lawyers, it makes a lot of sense to prioritize knowledge, because it's the knowledge that you are going to sell. And if you are going to compromise that because you want to make quick money, that just won't work. You have to have a long-term view of your practice. And for that, investing in yourself is the most important thing to do. And it's important to take precautions so that at the nascent stage of the law firms, people are not carried away with things which they think lucrative, yet in actual fact, they are there just for a very short time. I remember when we started practice, we used to just register companies and charge clients for $2,000, $3,000, and they would pay. Now, very quickly, that money just disappeared within a flash of a second because now registration can be done online.
Exactly.
I also recall speaking to my colleague when I was still president of East Africa Law Society, my colleague who was the president of the Law Society of Kenya, when the Law Society was engaged in a battle challenging registration of land titles and mortgages using a land administration system. And I told him, you know, I can feel the pressure you're having from the young lawyers, but please be honest. Give them the honest advice that the money that was previously in mortgages and processing of land titles has now disappeared because you cannot resist the employment of ICT tools in courts and succeed because society has moved on. And so looking at what the landscape is today, I think it would be useful for the younger lawyers especially. I mean, even some of us, we need to go that direction. Look at what are the emerging trends in the law where you can actually add value. Take the example of artificial intelligence that was spoken about earlier. It's pointless to resist that development because you can't do much about it. But then can you find a way of being relevant so that then you can add value there? Look at emerging trends like carbon trading, because environmental law and its role in managing climate change is going to be very important. There is a lot of work there. So get familiar with things like, you know, the carbon credits and how they are traded, because that is the future of the law. Today, we have a lot of questions being asked about compliance generally, because all of a sudden anti-money laundering and compliance generally has become relevant, both especially in the big economies, and everybody wants to make sure that whatever they are doing is really compliant. So you need to invest in that kind of knowledge. Like I said before, if you're going to survive in this business, you've got to be a lifelong learner. Because just as you are thinking that you are entrenched in a certain business, technology can simply sweep it away in just a matter of, you know, months or a year. I would also add things like trade, because trade will never disappear and there will always be disputes. So just keep on the lookout. You know, if there is money to make, by all means, make it, but don't get stuck. Don't compromise investing in yourself because you don't have time. You have to create the time for improving yourself. That might require lots of sacrifices, but that's an imperative. You can't run away from it.
Thank you, Richard. Mr. Zawandora, You were very passionate about ethics, and Professor Sempebwa touched on it as well. I have a question about complaints about quality of legal practice, ethical issues among other professional tainting incidents, especially among young lawyers. How did you, in the past, you and others in your ilk, manage to succeed without having as many disciplinary matters? What is your advice to young lawyers, which I think the last part of it, you actually touched upon it in your previous comments.
May I ask to Professor Sempebwa to talk before me? I think.
Professor, how did your ilk at the time handle disciplinary issues and ethical dilemmas, which is becoming increasingly a problem for the young professionals?
Yes, I would start by saying that there were not many. They were almost, for my first 15 years or so of practice, I didn't really witness any serious disciplinary issues going to the disciplinary committee of the Law Council. It's only in the later 80s and then 90s that things have become worse. There's, I think, a tendency for some young lawyers to look at seniors and really hope that they can achieve financial-wise their standards in a short period. During our time, of course, you had to work and work and work and improve yourself, your financial standing. And part of the success lay in being honest, having no ethical issues. It was a must. I mean, even the way we'd been brought up meant that you couldn't involve in corruption and things of that nature, cheating clients and so on. So we didn't have this experience. It's a new one, but I think it comes from that approach that you can equal the seniors in a short time. And a lot of mentoring is required.
David, you might want to mute your microphone. Thank you.
Yes, I was saying that a lot of mentoring is required for us to have improvements in the profession. It's not only about ethics, it's also about other things like etiquette at the bar, as well as etiquette counsel to counsel. These are things that are worrying. You see young lawyers in court having exchanges with judges, which should not happen. Maybe I'm speaking like you might say I'm archaic, but it shouldn't happen. There's a way of responding to a judge without being involved in heated exchanges. Otherwise, some of us who have taught most of the bench would be going to the court and saying, shut up, I know more than you, I taught you, and so on. So etiquette is also a big problem, and this is not a disciplinary matter. But the question is to my friend from Burundi. I hope I have introduced it without depriving him of the opportunity to say something.
Thank you, Mr. Professor. Just one word or two about that question, how to solve, how we, in our experience, how we come up or how we face disciplinary matters. So it's very now, there is a plenty affairs, plenty cases, disciplinary cases, because of young lawyers frequently are very they are very quick to get money. When they see, for instance, Professor Mpebwa with a car, with a type of a car, they want it. And when they see the colleague has a car, the type of car, they want to get it. And they think that it's 1 or 2 days after you can get that type of car or some a comfortable situation. I think they have to be go very slowly. They think about and they get experience because and they get a model. If a young lawyer has not a model, he can't go anywhere. The other thing to say is to follow the conduct law extremely. It's very important. And of course, if a young lawyer want to become a famous lawyer as Mr. Sempebwa, is to I think I advise them to be humble, be very humble in everything, and always get advice for elders, advocates, elder colleagues, and of course, not to think much more about money. Money is just a part of life. It's a part of half of an advocate. But the important thing is how what can I say? How righteous you are. If you are corrupt or something like that, you don't go anywhere. So my advice is finally to ask to young lawyers to be humble, to go slowly, to get experiences, to work hard, and to get to have a model, and to get advice always in everything. Thank you.
Thank you so much, Mr. Bandora. Ambassador, are you still with us? We have about 13 minutes left on the call. And I have a question. Cross-border practice has been the dream of many East Africans. However, there have been many bottlenecks. As a founder as one of the titans in East African society, what do you think needs to be done to realize cross-border practice?
Well, I don't know what to say, because when we talk of cross-border practice is assuming I come to Rwanda to establish office there. But we can work with Richard without having to set up an office. As I said, the first mentor that I had was a practice from Kenya. We didn't have any cross-border relationship, but the businesses brought us together. And what is happening is with the trade area that is now becoming more of a reality than it was, there will be no choice but to work together. What we see at the moment is the mismatch that is happening in the sense that if I expect to work with a Kenyan lawyer, that lawyer would also expect me to give him business, or I would expect also to get business in Nairobi. But the businesses are such that it's unlikely. So you may not even be doing cross-border business if you want. But also, we have, consider those who are forming regional practices, for example. That is cross-border business already. If we didn't have to leave ENS Africa, for example, we would be doing cross-border business. There's ENS Africa in Kenya. there is in East Africa. In Kampala, there is, but that was not the law firm's initiative. We can do our own initiative. So for me, cross-border means working together. And working together doesn't necessarily mean setting up practice in the other place of business. So cross-border is how you can work as a team. And you can always create teams in East Africa when there is business to create a business. But to just go try your luck in Kenya or try your luck in Dar es Salaam to establish an office, it may not be that successful even if there's no limitation for you to do that.
Thank you, Ambassador. Thank you, Ambassador. And I think there's a similar question for Professor Sempewa in the Q&A. It says, could Professor Sempewa please tell us what Rwandan advocates can do to be considered as equals in legal practice? It goes to him because he's among those lawyers in Uganda who have even sworn affidavits in courts to block Rwandan advocates from practicing in Uganda. This is Counsel Okumu Martin.
I think there is a misconception about this matter. Under the East African Free Trade or Common Market Protocol, we no longer have those restrictions. The Rwandan lawyer who has been enrolled in Rwanda can apply to practice in Uganda, and we have to admit him or her. This is our East African community law regime. It so happens that very few applications have been received because this right of free movement is accorded to non-nationals, not Ugandans. A non-national within the community, that means a Tanzanian, a Burundian, and a Rwandan. Now it will be Congo as well. I think what the person is asking is about Ugandan students who have done part of their training in Rwanda. And these are being caught by our old archaic law, which we have got to amend, which says that our own students must do their training in a common law jurisdiction. And we've struggled with this for quite a long time. And recently I was presenting at East African Law, the Uganda Law Society, and I said we should actually interrogate this difference between civil law and common law and see whether there is really a big difference, because it's becoming a nomenclature that, Burundi is not a common law system, and therefore our own lawyers, if they study there, they must be treated differently from the lawyers who have studied in Britain and in America and so on and so on. So that's the misconception. There's no Rwandan lawyer who can be prevented from entering and practicing in Uganda under the common market arrangements. Obviously, as Ambassador has been saying, there have been very few people taking it. I don't even know of any person who has taken advantage of this. I know that Ugandans are practicing in Kenya, but those are students who went there to do the back course at the Kenya School of Law. And because they know that our law, when you studied in a common law jurisdiction outside Uganda, our law requires that you do some practice in that state before you come back and get enrolled here. So they stay there for a year or two, but not because they have taken advantage of the common market freedoms. So I don't know what, but maybe Ambassador has answered the question that probably people don't feel they will do well by going to establish in other areas. They would rather be in alliances And these alliances, I think, are a matter that will devolve if we want to go ahead with cross-border practice, an alliance of legal firms that can work together and achieve cross-border practice. But to expect the right of establishment to be entertained by many lawyers is unlikely. So at one time when we exchanged views and the lawyers in Tanzania were worried about the influx of Kenyan lawyers and so on, it's not going to happen. I don't think they have had an influx of Kenyan lawyers ever since the Common Market Protocol was formed. But I wanted to clarify on this.
Thank you. And the combination of what you've said, Professor, and what the ambassador says, I think clarifies the matter. Unfortunately, we are running out of time, so I'll give our invited guests 1 minute each to conclude and give us parting shots, including if you have any career regrets, if any. We'll start with the ambassador because the professor has just been speaking, and then we'll end up with the professor.
Well, parting shots, I can say thank you, East Africa Law Society, for organizing this. And I think we should be doing more, talking generally about our experiences and what can do. Recently, we had this one on oil and gas, and it was quite interesting to see the comparison of the legal and regulatory regime for the natural resource. And you can see the differences and where we are completely aligned. And I think these are very useful. In the past, that's what used to be. We used to have aligned laws in East Africa. And I think that will be very helpful for a trading bloc to have an aligned legal and regulatory regime for doing business. So these discussions are very useful. The other thing I wanted to say is about, someone commented about artificial intelligence not replacing brains. It's not replacing brains for sure. But what will happen is the complex matters will not be handled by us, the gray matter issues that are coming. So we'll end up with the small crumbs on the table that to compete while the competition is now heating up more than ever. So I think we still have to understand and to see what can we take on at this particular stage and what we cannot. And I always say it's not happening slowly. It is happening very, very quickly. And we cannot just ignore what is happening at the moment. Richard mentioned things that we used to do ourselves too. Company formation was part of our business, and that was something that now you cannot charge much at all. People can set up companies legally. People can register businesses and can register mortgages online. Even we are doing court cases online. So the landscape is changing and changing very, very fast. And I think we have to take cognizance of that fact. Thank you very much again, Professor Sempemba, Richard, and Zibandora, Antonie, for your time, and also Florida for your moderation. Much appreciated.
Thank you, Ambassador. Mr. Zavandora, Antoine, your final words? You are muted.
Thank you. I'm very proud to be among this kind of panel, and I think our colleagues here in Burundi are impressed to follow such kind of forum to improve their knowledge, and of course to go forward and not to be afraid to speak, for instance, in a strange language which they are not used to be involved frequently. I don't know, ELS, of course, we can thank to ELS and encourage them to go forward. Thank you, all of you. And again, thank you very much.
Richard, final words?
Yeah, like my colleagues, I would like to express my gratitude for the organizers, to the organizers of this session. It gives us an opportunity to reflect on these important issues. My final thoughts are around what should we be doing to enable cross-border legal practice. I think it would be best if we focused on areas of the law that are non-jurisdiction specific, so that then we can synergize and probably create bigger teams that can work profitably across the region. I think that's much more palatable to the legal community, and probably even much more meaningful, because if I want to go and practice family law in Uganda or Kenya, I don't think there's so much value to add. But if we are working together to develop a mining practice or construction practice or an environmental practice that is not jurisdiction specific, and probably there is people will not be caught up in a protectionist mode. The second thing I would like to say is that even as you try to figure out your areas of specialization, always try to find something that makes your heart tick, you know? Yeah, as the saying goes, where your heart is, where you'll find your treasure. You will be most effective in the areas of the law that you really love. And because you love them so much, you will do them very well. And with doing them very well, the money will follow. Thank you.
Thank you, Richard. Professor Sempebwa, while giving your final remarks, I looked at the Q&A, and most young lawyers on the call were actually very concerned about specialization. Is it the advice of the Titans for young lawyers to specialize in particular areas of legal practice? And if so, when should they do it, right from the beginning or at the end? Please give them some insights while also giving up your parting shot.
There is no alternative to specialization. Otherwise, you are dead. You can no longer, that stopped in our ages, the early ages, that you could be a jack of all trades. Move from a criminal court and go to a family court or something like that. That era has stopped. You must specialize. And I think that also leads to a dead end, a one-man or one-woman farm, or very small farms, because then specialization will be difficult. So there's no alternative. We need to specialize, and I would like to add my voice to Richard, that the only way we can achieve a cross-border practice is first through specialization, and then through alliances over those cross-border transactions. Otherwise, we don't expect lawyers to go and establish themselves under the Common Market Protocol. And I would like to call on my colleagues, the teaching fraternity, to make sure that the teaching of law is oriented towards this new approach to legal practice. I would like to thank the organizers and my fellow panelists for this webinar, but I would like to end with one request to the East African Law Society, that maybe you give us some other training on the use of media by the lawyers, because it is becoming something, at least in Uganda, I don't know about the other areas, something that is getting out of hand of social media
Social media.
by practicing lawyers. Train us on how we can engage on social media. In Uganda, the trend is becoming alarming, where we abuse each other, we abuse judges, and so on and so on. But thank you very much.
Thank you, Professor Sempewa. Thank you to all our guests for taking your time to be with us. Thank you to East African Law Society for inviting the Titans to be on this call. Thank you to the participants for your questions, for your comments. This has been very insightful. I have learned a lot, and I'm grateful that we have all heard from all of you. We learn new things every time, and we learn from each other. I want you to know that we are all grateful, and on behalf of the participants from wherever they are, they joined us at one point. I think we had 230 participants. So thanks to all of you, and have a good afternoon.